a speech, I would like to speak from the heart. My very honorable and distinguished colleague who's be retiring, not today, but on the 11th of March, when it will be his 65th birthday, mentioned that his first encounter with the English language was in the 6th class. My first encounter with him was when I, as the Chief Justice of Buluchistan, was attending a conference, and it was an international conference, and there were two entrances, one for foreign dignitaries and one for the rest of us. So the person at the gate said, "Sir, you come here." So the foreign dignitary on my right, he understood him with such a fair complexion that he couldn't possibly be a judge of the Supreme Court. And I thought he's a foreign dignitary, and then I later heard him speak in chaste Urdu. So I said, "Where did you learn Urdu?" That's my first encounter with him. And it has since been every encounter has been extremely pleasant. I did not know him before. Yes, he was from the district of Rawalpindi here, 1985. He became a counsel, then an advocate, then he became an additional judge of the High Court, 1987. He contested the bar elections as well and won as president. Thereafter, sorry, I beg your pardon, then in 1987 he became an advocate of the High Court. And in the year 2009, he was appointed as an additional Lahore High Court judge, was confirmed, but unfortunately, though fully deserving of the position, did not become the Chief Justice of the Lahore High Court. The loss was of the province. The gain was of the Supreme Court when he was appointed on the 6th of November 2015 to the Supreme Court. He has performed, I would want to just dilate first on his judgments, a few judgments only. There are many of them. You've heard the figures, 13,000 plus. It embarrasses, I'm sure, not just me, but many of us. He was in between, he was not well. But despite that, he would say, "Saab, kitne case rahe ho? Aap lagane 40-50 cases. Aap kaise handle karenge?" He himself encouraged the maximum number of cases are fixed before him because he felt for those who had not had their say in court, and he ensured that they should as soon as possible. I just want to refer to a few judgments of his. One is the famous judgment of Asfandiar versus Kamran in 2016, SCMR 2084, in which, these are judgments which held something new, that there's a provision in the Code of Criminal Procedure, Section 539B, to appoint a commission. And sometimes judges would appoint others as commission, and Sardar Sahib held that in I'll quote, under Section 539B of the CRPC, the trial judge had no power to appoint another person to visit the place of occurrence as a commission, because the report submitted by local commission cannot be equated with the memorandum mentioned in subsection 1 of the provision. The trial judge can inspect the place of occurrence but alone, and he cannot delegate his powers. So this was something which had been left unattended. In the same judgment, he also commented upon the fact that some lawyers have stopped reading different provisions available in the code and just move an application under the Omnibus Section 561A, and he correctly noted that this is not an alternate or substitute for an express remedy that is provided in the law, and unless there isn't, then recourse should be made to this provision. This was in 2016, now we come closer in time. Another judgment is the Model Customs Collectorate of Islamabad versus Amir Mumtaz Qureshi, reported in 2022 SCMR 1861. And here his lordship dilated upon 249A and 265K of the Code of Civil Procedure to that rather than face a complete trial, these provisions can be availed of if there's nothing in evidence which may result in a conviction. However, if there's a possibility of a conviction, then recourse should not be had to these provisions. A few more, if I may just mention, that is more recent, 2023, the case of Amir Faraz versus the state, 2023 SCMR 308, where his lordship cancelled the bail of someone, because generally we have very rare precedents in this regard, and he noted that misusing the same by hampering the trial, as on numerous dates of hearing the prosecution witnesses appeared before the court, but their statements were not recorded on the request of the defense counsel, etc., etc., and that he was misusing his concession of bail. So bail was cancelled in this case, which is a misuse on people file cancellation of bails. They forget the parameters, the narrow parameters within which this relief can be sought, and his lordship identified these as mention has been made of the narcotic cases. I will just mention another one here, and that is that when the best evidence is available to the prosecution, this is the case of Ahmad Ali versus the state, 2023 SMR 781, and if it has been withheld for no good reason, then an adverse presumption will be drawn, and the benefit of that will go to the accused. One can go on and on, as all those who practice on the criminal side will know, that in fewer cases, the law or something new is being said. So in civil cases, you'll find them all the time, but in criminal cases, because the principles are pretty well settled, or they just deal with the merits of the case and then really not attend to any legal point. But my distinguished colleague has always brought in the law in his judgments, which is useful, not just for students of law and for lawyers, but also for his colleagues as well. Recently, mention was made of the Zulfikar Ali Bhutto reference case, which had been pending for a very long time. And one of the reasons which propelled me to fix it was that my colleague won't be with us for long, and he, more than anyone else on the bench, will be the greatest asset to ascertain the ins and outs and complexities of a criminal trial. So that was the reason which prompted it, and which at times I tried to hurry the case along as well, because I wanted his benefit of his elucidation of legal principles, which he provided, and how to attend to it. And we have attended to the matter and rendered our opinion to the President of Pakistan,